Hello, I'm John Pugh-Smith. I'm both a practicing barrister and also a mediator. And in this short piece, I want to explain a little bit more about mediation in a planning context. Now, that context arises as a result of a recent announcement from the Chief Planner of the Ministry of Housing and Communities and Local Government about the introduction of a Pathfinder initiative with the Planning Inspectorate. So let's start with the essential elements of mediation. Now, the process in itself is very straightforward. It's the introduction of a neutral third party to facilitate a negotiated settlement. And it can be any type of dispute, and indeed the negotiation, insofar as it needs to be mediated, can achieve a range of different outcomes, which, of course, in a development plan context, can include issues to do with a planning application and in enforcement context, whether or not retrospective planning permission should be granted or an amended planning permission issued, or indeed extended times and processes by which the planning enforcement issue can be resolved. Of course, it's entirely voluntary, it's without prejudice, which means that it can't be relied upon in later proceedings. And of course, unless the parties agree otherwise, the whole process is kept confidential. Typically, it takes place over a day in a suite of rooms at a convenient location or remotely via platforms such as Zoom. It usually includes a combination of sessions, and those can be either jointly with the mediator or privately, depending upon the nature of the issues being discussed. So let's turn to some key points about mediation, particularly with enforcement cases. First, it's important to bear in mind that mediation does not remove the need to act within the statutory code, nor avoid transparent decision-making that takes into account the public interest, nor usurp the role of committees and councillors. Secondly, because it's flexible, the process can be designed to respect those interests while still delivering positive outcomes. That means that the mediation can more directly respond to the needs of the parties, for example, exploring alternative outcomes that might avoid or sufficiently lessen the planning harm in question, as well as meet third-party objections and at the same time perhaps facilitate certain landowner objectives. Now, so far as the process itself, it can involve not only the opportunity to resolve disputes between the stakeholders in confidence, but it can also avoid adverse publicity, which arises through the appeal itself or other legal processes. Finally, and importantly, it can cut short the lengthy and often expensive appeal process, which is currently subject to a substantial COVID-induced backlog. So, if you are a bit more convinced, can I make the following suggestions as you prepare for the mediation? First, your discussions can take place at any time with the other side or other opposing parties, and indeed can take place as soon as you want to start the mediation process itself. It is not a fixed point in time. Oftentimes, the willingness to mediate can be seen or perceived as a weakness in a party's case, but that is not the reality these days. It's showing a willingness to want to try and resolve the dispute. No more, no less, but significantly a positive step in an otherwise potentially very adversarial process. 2, once you agree to mediate, you should appoint the mediator with suitable experience, and the Planning and Mediation Appointment Service that is now jointly administered by the Chartered Institute of Arbitrators and the Royal Institution of Chartered Surveyors will direct you towards the type of mediator that you need with long experience both of dealing with these matters as a planning professional and also as a dispute resolver. The third aspect is the nature of the process itself. The appointed mediator will spend time consulting with you before the actual formal session gets underway, designing a process that is going to help you and the other party prepare effectively and achieve a degree of success. 4, the parties will be invited to provide relevant documentation to the mediator, and often that is taken to be in the form of what's known as a mediation or position statement, which sets out what they hope to achieve from the process. 5 on the scheduled day or days, the sessions will take place at a pace which works best for the parties, and indeed will include sufficient breaks and include refreshments as well. Finally, when preparing for the mediation, it's useful for you to consider, first, what you hope to achieve through the process. Secondly, you need to bear in mind that there has to be a willingness to listen and to explore compromise, not simply to put your position. So, if you are sufficiently convinced, as I end this, please, some concluding remarks. First, as a practicing planning professional and mediator, it's been my experience that the use of mediation and other related techniques do facilitate dialogue and can achieve positive outcomes in even the most protracted and ill-tempered disputes. Second, what may be seen as novel, the fact remains that the latest Pathfinder initiative is following a wave of not only interest but need by all forms of dispute resolution bodies, and I embrace here not just in the context of the courts, but also in the context of the way in which government departments and other public bodies now operate to try and achieve more effective, quicker and cheaper outcomes. So, by way of conclusion, I hope that you'll become an active participant in this major sea change in dispute resolution and in the planning context. Thank you so much for listening, and I hope perhaps to see you myself in due course. Thank you. Goodbye.